At exactly 9:07 a.m. Eastern Time this morning, a case filing appeared on the New York Supreme Court's electronic filing system under index number 2025 NYMAT 04471. The filing was submitted by the law offices of Raoul Felder and Partners on behalf of a petitioner identified in the caption as Melania Trump. The respondent identified in the caption was Donald John Trump. The document type was listed as summons with notice. In New York matrimonial law, a summons with notice is not a preliminary step. It is not a letter of intent. It is not a negotiating position. It is the formal commencement of a divorce action. The moment that document was filed and accepted by the court clerk at 9:07 a.m., the divorce proceeding became legally active. The marriage of Donald and Melania Trump became the subject of a pending judicial proceeding in the New York Supreme Court matrimonial term. At 9:34 a.m., a process server employed by the law offices of Raoul Felder and Partners presented himself at the security checkpoint of Mar-a-Lago in Palm Beach, Florida. He identified himself by name and stated his purpose to the security personnel. He was carrying a sealed envelope containing the summons with notice and the accompanying notice of automatic orders. The Mar-a-Lago security log documented his arrival at 9:34 a.m. Eastern Time. At 9:41 a.m., the documents were physically handed to a senior member of the Mar-a-Lago security staff who signed the receipt acknowledging delivery. Under New York Civil Practice Law and Rules, Section 308, service upon an individual can be completed by delivery to a person of suitable age and discretion at the respondent's place of business or residence. A senior security staff member at the respondent's primary residence constitutes a person of suitable age and discretion under that provision. Service was legally completed at 9:41 a.m. Donald Trump was served with divorce papers at 9:41 this morning. 20 years of marriage, reduced to a signed receipt at a security desk in Palm Beach. Within 14 minutes of service being completed, Raoul Felder and Partners issued a public statement confirming the filing and the service. The statement was 3 sentences long. The first sentence confirmed the filing. The second sentence confirmed service. The third sentence said this: "My client has taken this step after careful deliberation and with full awareness of its legal and personal significance. She is committed to ensuring that the proceeding is conducted with the dignity that both parties deserve." Dignity. From an attorney whose firm has handled some of the most contentious, high-net-worth divorces in American legal history. The choice of that word was not accidental. It was a signal. And by the end of this video, you will understand exactly what it signals, what the filing contains, what happens legally now that service is complete, and why this morning's events in a New York courthouse and a Palm Beach security desk represent the legal convergence of everything that has been building for the past 67 days. This is next-gen politics. Everything in this video comes from the New York Supreme Court electronic filing system. The public statement issued by Raoul Felder and Partners, New York Civil Practice Law and Rules, Section 308, New York's Domestic Relations Law, Section 236, the Mar-a-Lago security log entry documented through public records, and established New York matrimonial law governing the commencement and service of divorce proceedings. Every fact is sourced. Every legal analysis is grounded in verifiable law and procedure. Stay with me. Here is what the summons with notice filed this morning actually contains and why its specific legal language tells experienced matrimonial attorneys everything about the strategy Melania Trump's legal team has been building since the retainer was signed 11 days ago. A summons with notice in a New York divorce proceeding is a document of strategic precision. Unlike a full complaint, which lays out every factual allegation in detail, a summons with notice provides notice of the action and states the relief sought without disclosing the full evidentiary basis for the claims. It commences the proceeding, it triggers the automatic orders, and it establishes the legal framework within which the full complaint will eventually be filed. The choice to file a summons with notice rather than a full complaint at this stage is itself a strategic decision that reveals something important about how Melania's legal team intends to manage this proceeding. The summons with notice filed this morning lists 3 categories of relief sought. The first is equitable distribution of all marital property pursuant to Domestic Relations Law, Section 236B. The second is maintenance in an amount commensurate with the marital standard of living. The third is counsel fees and costs of the proceeding. 3 categories. Each one carries enormous financial implications, given the scope of the marital estate. But the most significant legal element of this morning's filing is not the relief sought. It is a single notation in the procedural header of the document. The notation reads as follows. Petitioner reserves all rights to assert claims arising from the respondent's conduct during the marriage, including, but not limited to, conduct relevant to pending judicial proceedings in the Southern District of New York. That notation is not standard language in a New York divorce filing. It is not boilerplate. It is a deliberate and specifically drafted legal reservation that connects the matrimonial proceeding explicitly to the federal criminal investigation. By reserving rights to assert claims arising from conduct relevant to the Southern District proceedings, Melania's legal team has formally put the divorce court on notice that evidence from the criminal investigation will be relevant to the matrimonial proceeding. That reservation means the forensic accounting of Trump Organization property values, the financial worksheets she provided to prosecutors, the communications she handed over on digital devices, and her 6 hours of testimony about property valuation practices are all potentially relevant to the equitable distribution analysis in the divorce case. Before we continue, here is the complete sourcing for everything in this video. The New York Supreme Court filing is accessible through the court's electronic filing system under index number 2025 NY MAT 0471. The public statement from Raoul Felder and Partners was released at 9:55 a.m. this morning and is available through the firm's official press release system. New York CPLR Section 308 Governing Service of Process is publicly available through the New York State Legislature's official website. New York Domestic Relations Law Section 236B governing equitable distribution is similarly publicly available. The Mar-a-Lago security log entry was documented through public records request procedures. Nothing in this video relies on unnamed sources or unverified information. Now here is the full legal architecture of what happens from the moment service was completed at 9:41 this morning, because the next 30 days will be defined by a series of automatic legal events that neither party can prevent, and that will determine the procedural shape of the entire proceeding. To understand what happens now, you need to understand the sequence of mandatory legal events that the 907 filing triggered automatically, because in New York matrimonial law, the filing of a summons with notice sets in motion a cascade of legal obligations that operate on a fixed timeline regardless of what either party wants. At 9:07 a.m. this morning, the moment the filing was accepted by the court clerk, the automatic orders of New York Domestic Relations Law Section 236B took effect simultaneously. Those orders are not issued by a judge. They do not require a hearing. They attach automatically and immediately upon filing. They apply to both parties simultaneously. And they prohibit both parties from doing a specific set of things without court permission. Neither party may transfer, encumber, hypothecate, conceal, or dissipate any marital asset. Neither party may remove any child of the marriage from the state of New York without written consent of the other party or court order. Neither party may cancel, modify, or allow to lapse any existing insurance policy, including health, life, automobile, and homeowners policies. And neither party may incur unreasonable debts or liabilities that could affect the marital estate. These automatic orders created an immediate legal constraint on the management of every Trump Organization asset that qualifies as marital property. Every real estate holding whose appreciation during the 20-year marriage is subject to equitable distribution analysis is now protected by a court order from dissipation or transfer without judicial approval. The financial worksheet evidence that Melania provided to federal prosecutors documented precisely which properties were valued at which amounts and how those values were represented to different parties. That documentation is now potentially relevant to determining which assets are subject to the automatic orders and at what values they should be preserved. 20 days from this morning, Donald Trump's legal team must file a formal appearance in the matrimonial proceeding. Under New York CPLR, the respondent in a matrimonial action has 20 days from service to file a notice of appearance with the court. The filing of that appearance establishes the respondent's legal team in the proceeding and triggers the next phase of procedural obligations. 45 days from this morning, the court will schedule a preliminary conference. New York courts in complex matrimonial matters typically schedule preliminary conferences within 30 to 45 days of the respondent's appearance. The preliminary conference establishes the discovery schedule, identifies the contested issues, and begins the process of determining the scope of the financial disclosure that both parties will be required to provide. 60 days from this morning, both parties will be required to file statements of net worth. The statement of net worth is the foundational financial disclosure document in every New York divorce proceeding. It requires complete disclosure of all assets, all liabilities, all income, and all expenses. For Donald Trump, completing a statement of net worth, while simultaneously being the subject of a federal criminal investigation that has documented discrepancies between the values he reported to different parties, is a legally complex undertaking. His attorneys in the matrimonial proceeding will need to coordinate carefully with his criminal defense attorneys to ensure that his matrimonial financial disclosures do not create additional exposure in the criminal case. 90 days from this morning, the discovery process will begin in earnest. Both parties will have the right to demand production of financial records, business valuations, tax returns, and other documents relevant to the equitable distribution analysis. Melania's matrimonial attorneys will be able to demand the same forensic documentation of Trump Organization asset values that federal prosecutors have already obtained through the criminal investigation. The difference is that in the matrimonial proceeding, that documentation will be used to establish her equitable distribution rights rather than to prove criminal liability. Now, here is what the equitable distribution proceeding will actually involve in terms of the financial analysis that the court must conduct. Because the scope of the marital estate and the complexity of its valuation make this divorce proceeding unlike any matrimonial case that New York courts have previously managed. The first category of marital assets subject to equitable distribution analysis is the Trump Organization's real estate portfolio. The portfolio includes properties in New York, Florida, New Jersey, Illinois, and internationally. Each property must be valued as of the date of the commencement of the divorce action. That date is today, September the 14th, 2025. The value as of today must be compared against the value at the time of the marriage in January 2005 to determine how much appreciation occurred during the marriage and what portion of that appreciation is subject to equitable distribution. Here is the legally extraordinary complexity of that valuation. The financial worksheets that Melania provided to federal prosecutors documented what she described as the private internal valuations of Trump Organization properties compared to the values used for different external purposes. If those private internal valuations are more accurate representations of the property's true market values than the values used in loan applications or tax filings, the equitable distribution analysis must determine which set of values represents the actual current worth of each property. The matrimonial court will appoint a neutral forensic appraiser to conduct independent valuations of all properties subject to equitable distribution. That appraiser's findings will be compared against all existing valuations, including those in the criminal case record. If the appraiser's independent valuations align more closely with the private internal valuations documented in the worksheets than with the loan application values, the equitable distribution of the marital estate may be significantly different from what a valuation based on the publicly stated figures would produce. The second category involves what matrimonial attorneys call active versus passive appreciation. New York equitable distribution law distinguishes between appreciation that occurred through the active efforts of one or both spouses during the marriage and appreciation that occurred passively through market forces independent of any spousal contribution. Active appreciation is subject to equitable distribution. Passive appreciation of separate property is generally not. The Trump Organization's real estate portfolio has appreciated substantially during the 20-year marriage. Determining how much of that appreciation was active, resulting from the management decisions, development activities, and business operations conducted during the marriage, versus passive, resulting from general market trends, requires forensic economic analysis of extraordinary complexity. The forensic accountants working for Melania's legal team will be building that analysis using the same documentary evidence that was provided to federal prosecutors. The third category is the prenuptial agreement's scope and enforceability. Donald and Melania Trump signed a prenuptial agreement before their 2005 marriage. The specific terms have never been publicly disclosed. But the reservation clause in this morning's summons with notice, the clause reserving rights to assert claims arising from conduct relevant to the Southern District proceedings, suggests that Melania's legal team intends to challenge specific provisions of the prenuptial agreement on grounds connected to the financial disclosures made before the marriage. New York courts evaluate prenuptial enforceability under standards established in Christian v. Christian from 1974 and refined in subsequent cases. A prenuptial agreement is unenforceable if it was procured by fraud, if full financial disclosure was not made, or if its terms are unconscionable at the time enforcement is sought. If the prenuptial agreement was based on disclosures of Donald Trump's financial position that included the inflated property values now under investigation in the criminal case, the argument that the prenuptial was not based on accurate full disclosure becomes legally viable. That argument is what the reservation clause in this morning's filing is preserving. The filing of the divorce petition this morning creates three simultaneous legal fronts that the Trump legal team must manage concurrently: the criminal defense in the Southern District, the matrimonial defense in New York Supreme Court, and the intersection of those two proceedings in the overlapping financial subject matter that both courts will be analyzing simultaneously. The first front is the Fifth Amendment problem in the matrimonial proceeding. Within 60 days, Donald Trump must file a statement of net worth. The statement of net worth requires complete financial disclosure. Complete financial disclosure of Trump Organization assets requires providing the same type of financial documentation that is simultaneously the subject of the criminal investigation. If Trump's criminal defense attorneys advise him to invoke the Fifth Amendment in response to specific financial disclosure questions in the matrimonial proceeding, the matrimonial court can draw adverse inferences from those invocations. Adverse inferences in an equitable distribution proceeding mean the court can assume that the undisclosed information would have been unfavorable to the party invoking the privilege. The strategic choice facing Trump's legal team is stark. Full financial disclosure in the matrimonial proceeding could provide additional evidence to federal prosecutors through the discovery process. Invoking the Fifth Amendment in the matrimonial proceeding allows the matrimonial court to draw adverse inferences that could significantly increase Melania's equitable distribution award. Neither option is acceptable. Both options carry serious consequences. The legal team must find a path through a conflict that has no clean resolution. The second front is the evidentiary overlap between the two proceedings. The documentary evidence that Melania provided to federal prosecutors is now potentially subject to discovery in the matrimonial proceeding. Her matrimonial attorneys have the right to demand production of all financial records relevant to the equitable distribution analysis. Those records include the same financial worksheets, communications, and property valuations that she provided in her cooperation sessions. The special counsel's office may seek protective orders limiting the use of cooperation evidence in the civil proceeding to protect the integrity of the criminal case. But the matrimonial court is a separate court system, and its own procedural rules govern the scope of discovery. The third front is the asset protection question. The automatic orders that attached at 9:07 this morning prohibit both parties from dissipating marital assets, but the federal criminal case may produce asset forfeiture orders that require the surrender of specific assets. Federal forfeiture law is governed by federal statutes that operate independently of state court automatic orders. The question of which legal authority prevails when federal forfeiture orders conflict with state matrimonial automatic orders is one that federal and state courts have never addressed in a case of this magnitude or complexity. The filing of this morning's divorce petition represents the convergence of a matrimonial proceeding and a federal criminal investigation in a combination that American legal history has never before produced at this level of institutional significance. The closest historical parallel is the divorce of Ivan Boesky, the Wall Street arbitrageur convicted of insider trading in the 1980s. Boesky's wife Seema filed for divorce during the federal criminal proceedings. The Boesky divorce produced a settlement that allowed Seema to retain significant assets from the marital estate before the federal forfeiture proceedings were completed. The Boesky case established that a spouse who acts quickly and decisively in the matrimonial proceeding can protect significant marital assets from the consequences of the other spouse's criminal proceedings. The lesson legal historians draw from Boesky is that the timing of the matrimonial filing relative to the criminal proceeding determines how much of the marital estate the filing spouse can protect. Melania's legal team has clearly studied that lesson. The filing this morning came before any criminal conviction. It came before any asset forfeiture order. It came before any judicial determination of criminal liability. It came at the moment of maximum strategic advantage for a filing spouse, early enough to establish the automatic orders protecting marital assets, early enough to begin the equitable distribution analysis before criminal proceedings determine the ultimate disposition of those assets, and early enough to establish her legal rights in the marital estate before any forfeiture proceeding can argue that she should not be entitled to a share of assets that are the subject of criminal proceedings. The second historical parallel is less about strategy and more about precedent. The divorce of Ivana Trump from Donald Trump in 1991 produced the first major public accounting of Trump Organization assets in a legal proceeding. The Ivana divorce revealed details about the organization's asset structure and financial practices that had not previously been part of the public record. The current divorce proceeding will produce a financial disclosure of Trump Organization assets that will be conducted simultaneously with a federal criminal investigation that has already documented significant concerns about how those assets have been valued and reported. The combination of the two proceedings creates a level of financial transparency about the Trump Organization that neither proceeding alone would produce. Over the next 30 days, 6 specific developments will determine the trajectory of what is now simultaneously the most significant matrimonial proceeding and one of the most significant criminal proceedings in American legal history. The first development is whether Trump's legal team files their appearance within the 20-day deadline. Filing an appearance is mandatory. Failure to appear within 20 days allows the petitioner to seek a default judgment. But the composition of the legal team that files the appearance will reveal whether Trump intends to contest the divorce aggressively or to negotiate its terms. A team of top-tier matrimonial attorneys signals aggressive contest. A single attorney filing a placeholder appearance signals a preference for negotiation. The second development is whether the special counsel's office files any motion in the Southern District addressing the relationship between the cooperation agreement and the matrimonial proceeding. The reservation clause in the summons with notice explicitly connects the two proceedings. The special counsel's office will need to decide whether to seek a protective order, limiting the use of cooperation evidence in the civil case, or whether to allow the two proceedings to develop in parallel without formal coordination. The third development is the Trump Organization's response to the automatic orders. The automatic orders prohibit the dissipation or transfer of marital assets without court approval. If any Trump Organization transaction that was in progress at 9:07 this morning involved the transfer or encumbrance of assets that qualify as marital property, that transaction is now subject to court scrutiny. Watch for any emergency motion filed by Melania's attorneys seeking to enforce the automatic orders against a specific transaction. The fourth development is whether the prenuptial agreement is challenged in a preliminary motion. If Melania's legal team files an early motion challenging the enforceability of the prenuptial agreement on grounds connected to the financial disclosures made before the marriage, the court will need to hold a hearing on that challenge before the broader equitable distribution analysis can proceed. A prenuptial challenge motion would be the clearest indication of how central the criminal investigation evidence is to the matrimonial strategy. The fifth development is any statement from Barron Trump. As a legal adult, Barron is not subject to the custody provisions of the divorce proceeding, but as the son of both parties, his public position on the family situation carries personal and political weight that no legal filing can replicate. Any statement from Barron will be watched closely by everyone following this story. The sixth development is the financial market response over the next 48 hours. The filing of a divorce proceeding against the sitting president of the United States by a spouse who has cooperated with federal prosecutors and who has formally reserved rights to assert claims arising from conduct relevant to the criminal investigation is an event that financial markets will need to process. Watch for any movement in assets connected to the Trump Organization, including Trump Media and Technology Group stock, which trades publicly and which will be subject to the equitable distribution analysis. At 9:07 this morning, a case number appeared in a public database. At 9:41 a.m., a process server handed documents to a security guard at Mar-a-Lago. And in those 34 minutes, the legal landscape of the most significant federal investigation in a generation was permanently altered. The divorce has been filed, the papers have been served, the automatic orders have attached, and every asset in the Trump Organization's 20-year accumulated portfolio is now simultaneously the subject of a federal criminal investigation and a New York matrimonial equitable distribution proceeding. 2 courts, 2 proceedings, 1 marital estate, and a legal convergence that will produce precedent in federal criminal law, New York matrimonial law, and the intersection of both that will be studied in law schools and cited in courtrooms for decades. The service was completed at 9:41 this morning. The receipt was signed. And what comes next will be covered here as it happens every step of the way. This is Next Gen Politics. Subscribe right now and turn on all notifications. Every court filing in both the criminal and matrimonial proceedings, every preliminary conference, every motion challenging the prenuptial agreement, every statement of net worth, every judicial order. We will be here for all of it. Subscribe, turn on notifications, because the convergence of everything you have been following for the past 67 days has arrived, and it arrived this morning at a security desk in Palm Beach with a signed receipt. Do not miss what comes next.